Welcome to Military Justice and the Law, presented to you by Bulelani Sehu. In this episode, I will be discussing the directorate of Military Defense Counsel, especially the important role it has to play in giving effect to the right of military accused to legal representation. Generally, the right to legal representation is not novel in our legal system. In fact, as far back as before the democratization of South Africa, the right was recognized in the Criminal Procedure Act 51 of 1977 and at common law. Nonetheless, the exercise of the right to legal representation was expensive. The consequence thereof is that only the rich and the privileged had the means to retain and instruct legal representatives. In the constitutional dispensation, the right to legal representation is the bedrock of a fair trial. Accordingly, Section 35(3) of the Constitution of the Republic of South Africa 1996 guarantees every accused the right to choose and to consult with a legal representative, and he or she must be informed timeously of the existence of that particular right. Moreover, the Constitution is clear that an accused person must be provided with legal representation at state expense if substantial injustice may result. There is consensus in our courts that substantial injustice may ensue in circumstances where an accused person is unrepresented but is nevertheless charged with an offense that upon conviction may warrant the imposition of imprisonment. There are many such offenses, for example, assault or murder. In our criminal justice system, the provision of the legal representative at state expense is the mandate of Legal Aid South Africa. Of all the rights in the Bill of Rights, the right to legal representation is characterized by some academics as the right that is closest to being absolute. In other words, if there is a right that was to be unlimited, the right to legal representation will be that right. However, all the rights in the Bill of Rights may be limited in terms of Section 36(1) of the Constitution. That provision stipulates that the rights in the Bill of Rights may be limited in terms of a law of general application in an open and democratic society based on equality, dignity, and freedom, taking into account various factors including the importance of the purpose of the limitation and the nature and extent of the limitation. The exercise of the right to legal representation is important in our criminal justice system, so as in our military justice system, by reason that military trials and our criminal trials are basically conducted in the manner that is adversarial in nature. Apart from the Constitution, the right to legal representation is protected in the Military Discipline Supplementary Measures Act 16 of 1999. Accordingly, the MDSMA guarantees military accused the right to legal representation at state expense. It does not matter whether substantial injustice may ensue. So in actual fact, military accused are guaranteed the right to legal representation as long as they are in jeopardy of a conviction and punishment, regardless of an offense that they are facing. This is a distinction between civilian accused and military accused, because civilian accused who are not basically faced with charges that attract imprisonment in the event of conviction need not be given the legal representation. In the Military Legal Services Division, the entity that is responsible for affording the accused the right to legal representation is known as the Directorate of Military Defense Counsel. This directorate is under the command and control of the Director of Military Defense Counsel. Other defense counsel serve as senior defense counsel as well as ordinary defense counsel. All defense counsel must be officers in the SANDF, and they must be legally qualified. In other words, they must be holders of a law degree. The defense counsel must, when basically discharging their duties, be diligent and ensure that they put forward the best interest of the accused persons. This is not unique to military defense counsel. In fact, the Supreme Court of Appeal, in various decisions, has made it clear that the purpose of a lawyer, a defense counsel, is to advance the interest of the accused. So the role of a defense counsel is not of a ceremonial nature. It does not mean that the defense counsel must just stand next to the accused, speak for the accused only. That person must vigorously pursue the interests of the accused person. In actual fact, the Supreme Court of Appeal in State versus Dalingebo stipulated that the right to legal representation must be real. It must not be illusory. So essentially, the right to legal representation denotes that such a representation must be proper, effective, and competent, by reason that incompetent lawyering can wreck the trial and render it unfair. So, in this connection, I must mention that existing literature reveals that military accused are from time to time displeased with the services that they receive from the defense counsel. In fact, the jurisprudence of the Court of Military Appeals show that there are some accused persons who basically appeal to the Court of Military Appeals against their military defense counsel, where they allege that the defense counsel did not have their best interests at heart, either by reason that the defense counsel coerced them into pleading guilty, or the defense counsel, in conducting the trials, they did not basically act vigorously on their behalf. So those, they exist. Also, anecdotal evidence reveals that some accused persons, they have cynicism regarding the defense counsel, military defense counsel, by reason that they feel that the defense counsel basically just want them to finalize their cases by pleading guilty, although they deep down they feel that such a matter is a matter that warrants them to contest it. So, as I've already alluded to, it will be wrong for the defense counsel to prioritize his or her own interests above those of the accused person. I've mentioned elsewhere that military defense counsel are persons who must meet certain targets. And experience indicates that since the introduction of these targets, 70 cases per financial year in the case of defense counsel, there has been basically an increase in the number of the accused persons who are pleading guilty. One is mindful of the fact that each case must be weighed on its own merits. But one cannot stop thinking that the connection between meeting the prescribed targets and the employment security of the Military Defense Council basically affects the manner in which the Defense Council conduct their functions. The golden question to be answered here is what is the position if ever the accused person is not happy with the assigned defense counsel. I must basically make it clear that the accused person, although he is entitled to be represented by defense counsel, he does not have a right to choose a particular defense counsel. So if he or she is not happy with the services of the assigned defense counsel, that accused person reserves the right to basically ask or request for another available defense counsel. In the absence thereof, Section 23A of the MDSMA provides that the accused person's right to legal representation is not limited to the services of the Military Defense Council. Such a person may instruct an attorney or an advocate at his or her own cost. So in this episode, I've made it clear that there is a directorate of Military Defense Council, and it is mandated with the responsibility of representing the accused in the military courts. And that representation, when they conduct it, it must be diligent in order to advance the interests of the accused. I've mentioned that it will be wrong if the defense counsel prioritizes their own interests by reason of seeking to secure further contracts at the expense of the accused person, thereby subjecting the accused person to an incompetent lawyering. In my view, such an approach will amount to professional misconduct, and that will not only violate the MDSMA, it will also violate Section 35(3) of the Constitution. That is all basically I wanted to cover in this episode. In the next episode, I'll be discussing military judges, especially with regards to their assignment, the manner thereof. And that will be compared with how judges and the justices of the High Court, Supreme Court of Appeal, and Constitutional Court are basically appointed, as well as how magistrates are appointed. Until next time, I trust that you enjoyed this episode. And whoever has not subscribed, please make sure that you subscribe. Thank you.